Court does call the case of the People's State of Michigan versus Clarence Broach.
And then on behalf of the people, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Broach, who is approaching. Please state your name for the record, sir.
There's Broach. Thank you.
Thank you, Your Honor. I was first able to connect with Mr. Broach today. I have been able to provide him with discovery and get some update contact information. To that end, we're requesting a 2-week adjournment if the court would allow to discuss discovery.
Probable cause without objection will be adjourned March 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case of the People versus Dana Kirby.
Edward Droops on behalf of Dana Kirby. This is a waiver, Your Honor.
Your name, ma'am?
Dana Kirby.
This court's understanding that you're waiving your right to a preliminary examination. Is that correct?
Yes, sir.
You understand that's a proceeding that people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Go ahead.
Your Honor, we stand mute, waive reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for March 10th, 2025, 1:30, Judge Hammoud. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the People versus, is it Aisha Brown or Asia Brown?
Hannah Mackey on behalf of Ms. Brown, who is approaching.
Asia Brown.
Asia Brown.
Your Honor, at this time, we'd like to set this matter for a preliminary examination. All discovery is complete as far as we are aware.
And would the people have their witnesses available on the 11th?
We'll do our best, Your Honor.
Preliminary examination will be set March 11th in person before Judge 9 a.m. before Judge Valvo. Bond continued.
Thank you, Your Honor. Thank you, Your Honor.
Thank you.
That's it.
And that child. Yeah. CC, Judge Valvo. Court does call the case People versus Christopher Miller.
Edward Droops on behalf of Christopher Miller.
Yes, sir.
Christopher Miller, sir.
All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Right. The court's understanding of the plea agreement is that the defendant will be pleading no contest to the use of a controlled substance, that being cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor. That's correct, Your Honor.
All right. Has he signed an advice original?
Yes.
The basis for the no contest plea is,
Lack of memory, Your Honor.
may I have him sworn?
That's right. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Christopher Grandmother Jr.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of use of a controlled substance. Is that correct?
Yes, sir.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, two things about it I have to make sure you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest? No contest?
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form today, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 234638. Any objection to the court having reviewed that report?
Objection, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
March 12th at 9 a.m.
March 12th, 2025, 9 a.m. That's before me.
Your Honor, if I may address bond.
You may-
I did, my client wanted to address bond last time that we were here. He was previously remanded. The hearing before that, he's had some opportunity to think about his actions that he took. And he's going to be under the power of the court, and you will be the sentencing judge. I think that he'd be compliant and doesn't want to spend additional time in jail. I think that if he were to be released, he would properly test the community corrections. Everything should be out of his system at this point, including alcohol. And he would report.
Everything should be out of his system and he won't show up for testing drunk?
No, sir.
He will not.
Really?
I promise, sir.
How do I know that? You promised me before.
He is very apologetic. I have talked to him in custody about that. He would meet with probation. There's a lot that goes on to that he can provide for a sentencing, and he knows that you're going to be watching over him, and he knows that there'll be an immediate warrant, and he needs to take care of this. So I'm asking that he has it reduced down to a PR bond and community corrections order be put back in place.
How long has he been in?
21 days.
Yes, sir.
Maybe 20
Was
days.
not testing and drinking worth it?
No, sir. Absolutely was not. Trust me, I got a lot of bad things that happened while I was in here with the family, so I understand that.
All
my
your
fault.
fault. All
my fault,
your
yes, sir.
fault.
Absolutely. And he was nice enough to give me the chance, and I blew up my dang self. So that's what made it even harder while I was in there, knowing that I was in there for my own selfish act.
I'll send you over to community corrections. You're gonna test clean. No. Goes over. Been drinking. Did you think you weren't gonna get caught?
No, I knew I was, sir. But once I told you I was going to go there, I went.
I gotta figure out a way not to look so stupid up here. Because some people think I am. I don't know. We'll prep a new community corrections order. His previous bond is reinstated. I dare you to do anything between now and the 12th circuit.
Oh,
No, you make your own choices. But you now understand what I will do.
oh, absolutely. I understand. You definitely don't tolerate it. I learned that the hard way.
Thank you, Ron. Give me a call when you get out.
Thank you, sir.
Court calls the case of the people versus Zion Brown.
The people.
Michael Gaddy, Assistant Public Defender for Mr. Brown, who should be present via Zoom, Your Honor.
Hey, my name is Zion Brown.
Thank you, sir.
Your Honor, we'd ask the court to set this matter for a preliminary examination.
Your Honor, there was an offer to waive preliminary examination and seek HIDA in circuit court. I understand that's being rejected.
Yes, Your Honor, we're asking for an exam.
Discovery is completed, sir.
Yes, Your Honor.
People have their witnesses available March 11th.
Your Honor, could we test and go one more week, please?
Any objection to that?
Yeah, it just occurred to me that in reviewing the file, I didn't see any security video. If there is, I'll request it before the exam.
Well, but I don't want it, if it's not there, that's not going to be the basis to adjourn.
Okay.
So what do you want to do?
Your Honor, why don't we, if it's okay with Ms. Lundy and with Your Honor, why don't I ask for an adjournment of the PCC so I can see if there's any security cameras available.
Probable cause conference adjourned March 13th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
I'll need a green sheet, Mr. Okay.
Yes, I'll fill one out right now, Judge.
Court calls case of the people versus Anthony Warren.
Ashley Lonnie, people in all matters.
Assistant Public Defender Asi Bashir, here on behalf of Anthony Warren for 24F41590.
Anthony
And-
Warren.
Sorry, Judge. And good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Warren in case ending 0128.
So who did this? You did that?
Yeah, but I got.
Oh, okay. No, I thought, no, if you did it, it's fine. I thought Rushing was trying to do something.
What, submit something on a white paper versus a green paper? Judge, I would never.
Yeah, trying to.
I would
trying to
never.
slip something by me. I just.
Not
Okay,
me.
if you did. I'm good. All right. What are we doing on Mr. Warren's cases?
Your Honor, in case, I'm sorry, in case ending in 0128, there is some outstanding video discovery that the people, I believe, are getting. So, Your Honor, we're going to have to seek an adjournment on Mr. Warren's case ending in 0128.
Hey. And on the other matter?
On the 1590, Mr. Warren would like to set for a preliminary exam.
Okay. So on the 128 matter, I will adjourn.
I'm sorry, Your Honor. Sorry, Your Honor. 1 second. So my client's understanding, and is it okay if I address Attorney Rushing?
Your Honor.
You want to talk to Ms. Rushing?
Or
Your
just
Honor, I know.
No, go ahead. I don't
No,
care.
no. Your Honor.
It's here.
Your Honor, I already know what is going to be said because we had a different game plan coming in today. However, it was brought to my attention this morning just before the docket started that here was the outstanding video. And I know that Your Honor will not schedule this matter for a preliminary examination without that being done. So that's why there is the change.
She called you inaudible.
I did. A Hail Mary.
Understood.
Yeah.
All right, thank you. We just needed to clarify that. So at least on this.
So what do you want to do? I mean, if discovery is complete on your case, then I'll set it. But I mean,
Would you want to adjourn that as well?
No.
Okay.
or I'll wait.
Sorry, Your Honor. I wasn't.
No, it's okay. You might want to push down the microphone because everybody can hear what you said and it's being recorded. But okay.
Still here.
Judge, I'm still here. I'm just letting you know I'm still looking.
No, I know you're still here. I don't know. Miss Bashir they just turned around and had their own conversation. conversation.
What's going on in the case?
It's just like calling a janaza case.
Like to
What?
have cases go together?
Not necessarily. It doesn't mean.
At least Miss Bashir was in the room.
They do, they can do them. If anything, it just becomes a shock process.
I know you've said nothing today and I'm picking on you. I know, you're just sitting there, but
Continue to.
it's like an easy target.
Yes.
And apparently I have a lot of time, so I'm just filling space.
Thank you for your patience, Your Honor.
That didn't really happen. I didn't really have patience, but go ahead.
I'd like to confirm that we would like to set for exam on 1490.
149. I mean,
Sorry,
159.
1590, sorry.
You want that one set for exam?
Yes.
All right. And on that matter, discovery is complete.
There is surveillance that I've requested. We haven't had at least one adjournment on that matter, and Mr. Warren is in custody. And so we've discussed this and he would still like.
But that won't be, I mean, I don't know how important that is for your case, but it won't be a basis to adjourn that you don't have.
Yes, yeah. So that is why we're, he's in custody. We are not adjourning. We'd like to demand an exam anyway. And there was a previous adjournment in order to get that discovery.
Preliminary examination in that matter will be set for, on that case, March 11, 2025. 9 a.m. That's before Judge Valvo. It's in person. On that matter, bond will continue. On the other case, I will adjourn that out, waiting on the.
And Your Honor, I did disclose the police videos this morning. I was able to find them in the system, so they should be over to Ms. Rushing very short order. We can do a week on that one if the court will allow, since he is in custody.
That'd be greatly appreciated. Greatly.
We already have 141, but what the heck? More merrier. March 6th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Bring a lunch.
Oh, sorry. Your Honor, I just one other matter to address. I did see that this is scheduled for a bond violation hearing, but I did review the report for the 1590 matter, and it appears that the report is dated February 1st. Mr. Warren was arraigned on February 2nd. He wasn't under bond.
I know, I saw that.
Okay, great. Just wanted to clarify and make sure.
Unless you want me to violate it.
No, I just
Okay,
wanted to make
thank
sure
you.
that that's the
I'm-
record.
I'm done.
Great, thank you.
Court calls the case, People versus Jesse Crampton.
Morning, Judge Mike Gill, public defender on behalf of Mr. Crampton. Your Honor, I have submitted a green sheet. I am requesting an adjournment for the reasons stated in that sheet. He was taken from the jail. I confirmed that with
Got it.
jail staff yesterday.
We have no anticipation of any.
No, I found out late yesterday afternoon where he was.
So why don't I do this? We'll do March 20th, 2025.
Thank you, Judge.
And bond continue. Court calls case, People versus Jeffrey Williams.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Williams, who's approaching the podium. Mr. Williams, can you state your name, please?
Jeffrey Leon Williams.
Thank you.
Hello, sir.
Your Honor,
You're
you
requesting an
stated-
adjournment.
Yes, Judge. And I just want to let Your Honor know that if I was submitting it on a colored sheet, it would be or pink. It'd be pink, not white. Just want to let you know. That would be my quick slide.
Yeah, I know that. Which would irritate me probably more than these green lines.
Highly likely.
They're
But yes, that's
beautiful.
Your Honor, we are just seeking the adjournment. I do believe that there is outstanding video discovery. So just a brief adjournment
All
would
right.
appreciate.
I'll adjourn this matter out March 13th, 2025, 9 a.m. bond. In this matter will continue.
Thank you so much, Your Honor.
Thank you, sir.
Have a great day, Judge. That's it for me.
You do the same. Court does call the case, People versus Harold Dennis.